Good afternoon, dear colleagues and dear participants. Welcome to the third session of our conference on consumer law in the digital age. It's a great pleasure to moderate this panel. I would like to begin by expressing my sincere thanks to the organizers of this conference, especially our Dean, Professor Dr. Başak Baysal, and Associate Professor Pınar Çağlayan Aksoy. This session will be an hour, and I would like to introduce our presenters. We have approximately 20 minutes for each speaker, and after the presentations, we'll have a Q&A session. Without further ado, I would like to introduce our first presenter, Professor Francisco de Elizalde. Elizalde is an associate professor of private law at IE Law School, IE University. He currently serves as director of the Jean Monnet Center of Excellence for Law and Automation, and holds a Jean Monnet Chair in EU Digital Private Law. His work sits at the intersection of private law and digital regulation, and has been recognized both academically and institutionally, including citations by the Court of Justice of the European Union. Professor de Elizalde, we are happy to have you today. Floor is yours.
Good afternoon, everyone, and thank you also for the students being here. I would like to thank Professor Pınar for the invitation. It's always a pleasure to be in Turkey, which is probably one of the more welcoming countries that still exist. And I've been in Istanbul many times, but it's my first time in Ankara, and I was looking forward to it. So today I'm gonna try. I think that the organizer was probably, I don't know if on purpose or just by chance, that every presentation follows from the other one, and some things that I've gonna comment on follow on what has been discussed this morning. And I will focus on the transformation of control of terms, okay? Terms in a broad sense. I know that in Turkey you also have term control for consumers, but I'm taking a broader perspective to it, and focusing on the digital world, especially in the platform world, is how term control is reaching different levels, okay? So a more economic level or transactional level, a level connected to free movement provisions of the European Union, and also a constitutional impact, right? And the third thing is when I refer to the digital regulations, for those ones who are not familiar with them, I refer to the Digital Services Act, the Digital Markets Act, AI Act, etc. And there is something that one of my colleagues mentioned before, is that the EU has put in place a regulation of the online environment that is full of procedural checkups. And some author has called this the regulatory fetishism, okay? So the idea is that it seems that the regulation is called the risk regulation. It's a matter of checking boxes, which in the end could lead us to an absence of the law itself. And this made me think and connect to old legal theory. You know that this technical norms is implemented through codes of conduct, through process of standardization by standardization bodies that then have to be implemented and presume conformity with the law. And it's also implemented through algorithms, okay, by their own platforms implementing the law. And this made me think of Pashukanis. Pashukanis was one of the big legal theories during Lenin period in the Soviet Union. And he said that in the future of communism, when the ideal society would be reached, the law would disappear. And criminal law would be replaced by criminal policy in the hands of the state. And the law, private law, will be replaced by technical norms. Aren't we doing the same? Marx said that he put Hegel right side up. Are we putting Pashokanis right side up? Are we doing the same, but instead of the state dictating those technical norms, are they dictated by private companies? And this is the process what Hans Miklis has called the process of privatization and outsourcing of co-regulation. Okay, so we have these big programmatic laws, well, full of nice words, trustworthy AI and similar words, that in the end are implemented through technical norms that are left to private parties. With the idea that this knowledge is, when companies are better placed than the state in deciding which these norms are. And here we reach a point which is crucial. Do these technical norms, do these compliance procedures replace the law or not? And here we have a dual perspective in the EU. On the one hand, in the process of standardization with standardization bodies, the Court of Justice in James Elliott has said that this is law. Once published in the official journals of the European Union, this is law. On the other hand, we have the experience of banking, which is the precedent for this risk regulation. And banking, and following the Lehman Brothers and the financial crisis of 2007, 2008, banks claim to have complied with the regulation, but in the end there was a big challenge through the control of unfair terms across Europe, and in some countries it's still ongoing. So it was a revival of law over the compliance. Now, how does this look in the digital market? First of all, there is a restructuration of the internal market. So in the past, EU law was binary. So if you think, for example, in consumer law, there was on the one hand the consumer who acts for personal purposes, on the other hand the business who acts for commercial purposes. Now, on the one hand, we are seeing what's called a partition or fragmentation of the business side. For example, in the Digital Services Act, we have very large online platforms, very large online search engines. In the Digital Markets Act, we have gatekeepers, and even the European Data Protection Board is speaking about large online platforms in general. So we, according to this regulation, which some have termed to be industrial policy protection, we have big players, small and medium players. On the consumer side, we are seeing a dissolution of the concept of consumer. Okay? All these regulations target upon the user of services, the users of platforms, the users of this, and the consumer takes the back seat, right? And so my first question, and we were discussing this, is whether EU consumer law is being replaced by something different, which is EU private law, okay, or EU digital private law, rather than simply being consumer law, a law that will include companies, a law that will have several layers, and will have a different layout. Now, this takes us to several problems. One is the move from individual or transactional law that Monica was talking about before, the idea that these were individual transactions and transactions, to a more structural consumer law, if you wanted more structural private law, a private law of a system. If we really take seriously what the EU has said, that these are gatekeepers, that they control markets, well, this is not simply an individually based law, but this is taking a structural dimension. It already has, of course, an impact on individual norms. For example, if we think about aggressive parties, when a gatekeeper, and the law says, can pose a serious imbalance in the bargaining power, well, a person who can seriously abuse of you is in a higher position to provoke an aggressive practice. But that is one of the consequences. We have other consequences. If think of platforms, for example, especially big platforms, think of one that has been termed gatekeepers. We have, first of all, the inclusion of third parties. Okay, think, for example, of TikTok, okay, or X. You put a comment on X. Well, it's not just between you and X, it's between you, X, and third parties. This is not what consumer law was thinking about, which was just a B2C relationship. Second important thing, looking from the perspective of terms, the platforms through the terms are implementing what is done in the platform, but also the platforms are enforcing what's happening in the platform, what's called digital self-help. In the past, think of banks. Of course, you also entered into a standard form contract, but if you didn't pay the loan, they had to go to court. So there was a court enforcement. Here, this is not. There is a third aspect that if we take, again, I'm not taking a normative stance, I'm just taking what the law says. If we are really considering gatekeepers, this means that the terms, with their terms, they dictate the transaction. They can have the effect of impeding or restricting the freedom to provide services, which is a new constitutional provision. Okay, imagine that, for example, Amazon says, you won't sell in my platform. You as a business. They can be impeding this free movement. And there's a third perspective, which is the constitutional perspective with constitutional principles, but also with fundamental rights, which are present in one of these regulations. But again, going back to the example of X, with your post, you can be affecting someone else's honor, for example, right? So how we should think terms in the future is not longer, Monica, you're cited here, is not longer between individuals, but taking into consideration terms as an expression of private regulatory power. Now, I will go over the 3 levels, and that will be it. The first one is the transactional level. Well, here there is a deconstruction, first of all, of terminology. So in the Unfair Contract Terms Directive, which you have in your Turkish consumer laws, they talk about terms not individually negotiated. Now the laws, they don't care about it. Some say conditions, some terms and conditions, some general terms. There is a deconstruction of terminology which in the end can have some impact on the enforcement of them. And from there, the laws add some transparency requirements. Transparency meaning the capacity of understanding the consequences of a certain transaction. But it also adds other meanings, a meaning in competition, okay? And here it's about transparency of market prices. The DMA has some. And also is transparency in both reporting, and Casper mentioned some of the DSA transparency database is for this risk regulation is I let you know things. And also transparency for constitutional purposes, for example, in the statement of reasons that are given, right? And as I said before, because of this partition of the business side, we have on the one hand an expansion of term control. For example, the Data Act has a control of unfair terms. And we have new ways of controlling unfair terms, which is the FRAMT, the fair, reasonable, and non-discriminatory terms, which in the end they're saying there must be some fairness in the terms, which means somehow some terms can be unfair. This is another way of controlling terms that has been expanded precisely because of this breakup or the B side of transactions. And then there's, to me, the more problematic case of Article 14 DSA, which introduces a new control for the design and enforcement of terms in content moderation, which is different to what we have in the unfair contract terms, and we don't know how it will go, because it has some repetition in terms of objectivity, proportionality, and etc., which could result in an under-enforcement of the Unfair Contract Terms Directive. The second level is what's called the EU free movement provisions, okay? Especially the freedom to provide services, as I mentioned before. Well, there is some theory about this arising from sports. Anyone who likes sports, especially football, there is a lot of cases concerning FIFA. The idea that the free movement provisions do not only apply to states, as it was thought at the beginning, and competition law left for private actors, but the EU free movement provisions also are applied to private parties when one of it, as Shepard says, has the capacity of have private regulatory power. Okay? The importance to have actually control of certain market. And this was confirmed for the first time, the horizontal application, in some cycling cases in the 70s, right? And it's still ongoing. The European Super League was a club from my city, which was Real Madrid, who tried to establish a competitive league, and FIFA, of course, was not happy. And in this case, what was interesting is that for the first time, and I put 2023 for you to see as how this follows, this is after the DMA, this is the year after the DSA, and the Court of Justice for the first time moves from non-discrimination in the constitutional sense, gender, nationality, etc., the case of course were mostly about nationality, to economic non-discrimination. And they say is that FIFA cannot impose conditions that discriminate other competitors because of their regulatory power, right? And they add some requirements. They say FIFA's regulations must be transparent, objective, non-discriminatory, and proportional. We are starting to seeing these words everywhere, huh? Everywhere. My claim here is that if this applied to FIFA, if we take seriously the gatekeepers, why couldn't these norms of EU free movement provisions apply precisely to gatekeepers as Amazon, etc.? The third and last level is the constitutional level. Here, and we were discussing with some colleagues before, is not merely an economic transaction. And the EU digital regulations focus on procedure. Okay? So it's not simply about substance as it was, it's causing a significant imbalance in the economic rights and obligations of the parties, as the consumer law was. They are focusing on procedure, give statements of reasons, give right to appeal. These are impositions on private actors, right? The first move. The second move is the move from merely economic interest or the control of economic imbalances to illegality and non-economic interest. Think of the GDPR. There are many cases, and some have reached the Court of Justice, in which breaching the GDPR by a term can be an unfair term. Well, this is a long and unnecessary route, because if something is illegal, it should be necessarily void. But because some countries don't have the rules, and certainly we don't have it at a EU level, the use of unfair terms, the general clause, is used to control illegality. But do we really need to go through it? The Unfair Terms Directive was meant to control freedom of contract. But if already this is done by a mandatory law, this does not seem to be the best tool. And part of what's illegal de facto, what can be seen online, is again privatized. Because if we compare, for example, the Digital Services Act, Article 14, it says that content moderation is left to the terms and conditions of the companies. Okay? And this already has been reported that this has led to overblocking. Overblocking in the sense that content that is lawful has been taken down. And that, in principle, following these procedural laws, these digital laws, is okay. If you compare Article 14 with the precedent, for example, the terrorist content regulation, there only lawful content, unlawful content can be taken down, can be filtered. And it's also what the Court of Justice has said for the digital in the single market directive, copyright in digital single market directive, that said that filtering, automated filtering, can only affect unlawful content, okay? So the DSA opens the room for platforms to tackle down content that is not unlawful. And here we go back precisely to what Husoberg was one of the persons who was most involved in the DSA. He refers to the tension between administrability and precision. They say, okay, the algorithm, which in the end is the one that is enforcing these terms, must make a choice. For efficiency, some asked the question of efficiency before, it can not always be correct. Okay, it must somehow standardized. So precision, which in the end is the rule of law, is left aside over the administrability of the system. There was one case by a court of appeal in France last year in which there was a lawyer, many of you could be, a lawyer who was taking care of a criminal case of a person who had committed child abuse, and in his Gmail he had pornographic pictures, the lawyer's Gmail. And Gmail, also in the Google Drive. This was tackled down, okay? The account was eliminated, the information was lost, and the lawyer was saying that this was against his fundamental right, or better, the defendant's fundamental right to effective protection. And the court at the appeal level has said that Gmail was okay. So in the end, that what is proportional in terms of fundamental rights is again delegated. So what is the way forward? Okay. In this context of proceduralization, in this context where it seems that the digital regulations have taken over, in that context, with due respect, in which everything seems to be the digital constitutionalism, what is the role for private law? Okay. As we were discussing in the morning, private law is still relevant, as we have seen in some cases in the US concerning Meta and YouTube. Private law is still relevant, but it must change. It must adapt to the new situations. The first thing is we need to distinguish between intermediary and non-intermediary service. Non-intermediary could be a vendor when you buy something online directly from the seller. That's not the same in the case of a platform where there are third parties involved, where your participation, think of a gatekeeper, can be determinant to your business to actually access. It's a completely different situation. Second, we need to think if it's possible to integrate the three levels. Think of economic non-discrimination. Does it mean the same for transaction, free market provisions, or the constitutional level? Is there any way of integrating that? Or shall we act as EU law always does, as silos, completely different areas? The third point is whether constitutional law can help private law to rethink some concepts. For example, consent. We have taken consent very lightly, clicking, accepting, okay, yeah? And there's a way back connecting power, okay, which now can be the EU digital regulations, in the Meta case of 2023, where it says is the freedom can be affected in the case of abuse of a dominant position. Can we take that experience to rethink consent in private law, which is necessary to begin with to accept terms and conditions? Lastly, I have an invitation, is to revisit the control of unfair terms to gain some granularity. At this level, we cannot think exclusively of fundamental rights as a broad limit, as Article 14 DSA does. We need to think and distinguish structural from individual situations. We need to distinguish economic and non-economic interests, for example, mental health. And we need to have into consideration the third parties in any contract as opposed to any consumer right. Thank you.
Thank you very much for this engaging and interesting presentation, Professor De Elizalde. Now, my pleasure to introduce our second presenter, Associate Professor Dr. Hüseyin Can Aksoy. Dr. Aksoy is a faculty member at the Faculty of Law at Bilkent University, where he also served as Associate Dean for 5 years. He received his LLB from Bilkent University, his master's degree from Ankara University, and his PhD from Martin Luther University, Halle-Wittenberg, in Germany, I think. His research is widely recognized for its interdisciplinary approach, particularly in data protection law, law and economics, and European private law. He is the author of 3 books and numerous articles and book chapters published in national and international journals. He's received several prestigious awards, including national and international recognitions for his teaching and his research. Dr. Aksoy, I'm not going to talk about your presentation now, so floor is yours.
Thank you very much. It means a lot, you being my professor, and today being my chair and introducing me. I once again feel like a student. I went back like 20 years ago, and it's emotional, honestly. Okay, my dear colleagues, dear friends, and my lovely students, thank you for being here today. I greet you all respectfully. Today I'll be talking about consumer vulnerability in digital environments beyond the rational consumer paradigm. I think the title already gives a hint about the content of my presentation. Let's start with the very basics. What is vulnerability? Simply, vulnerability is a condition with two elements. One, there should be an individual whose ability to make free, informed, and rational decisions is diminished. And this must be caused by cognitive, economic, psychological, or perhaps social factors. And who is this vulnerable person that we are referring to? Well, classical legal models often tie vulnerability to specific groups. Children are vulnerable, elderly, old people are vulnerable, and persons with disabilities are regarded to be vulnerable. So, as a result, these groups need special protection mechanisms under the law. Yeah. Well, now let's move on to vulnerability of consumers under the EU law, and in particular, Unfair Commercial Practices Directive. EU law, EU consumer law links vulnerability of the consumer to internal characteristics of the consumer, which impair their capacity to engage effectively with commercial practices. So in EU law, there is a benchmark of average consumer, and if a consumer is below such benchmark, exceptionally, that consumer is regarded to be a vulnerable one. So according to UCPD, being vulnerable for a consumer is the exception. And this is caused by mental or physical infirmity, age, or credulity of the consumer, which makes some of these people more susceptible to harm, unequal treatment, and unfairness. So why? Why does the EU law make such an assumption? Because another assumption lies beneath, which is the rational choice theory of the neoclassical model. Monica and Kasper, in their presentations, both referred to the fact that UCPD deals with the distortion in a given moment, right? The transaction decision, the moment where the decision of transaction is made. And it is at this very decision that the UCPD assumes that the consumer is a rational person, is a rational agent. So as a rational actor, if you provide the consumer with the necessary amount of information, the consumer would be in a position to make the best optimal decision for themselves. So the EU consumer law just bombards consumers with information, assuming that they are rational and they would make the best choices for themselves. However, that's not the case. We are not all rational human beings. Modern literature, and especially the behavioral economics, just revealed how cognitive biases undermine informed decision-making. In simpler terms, it is not that we are acting very rational when giving decisions, but we are acting through shortcuts, and which I named as biases, such as framing effects, inertia, boundary rationality, and so on. And in the end, we mostly make, or at least sometimes make, irrational decisions. And firms simply exploit these biases to steer consumer behavior, which renders transparency-based protections largely symbolic. Now let's come to the digital age. what has changed in the digital age with regards to vulnerability? The rise of the digital marketplaces over the last 2 decades has reshaped consumer interactions. Consumers today have a dual role. One, they are purchasers. They purchase goods from stores or online. This is the classical role of the consumers. But within the digital market, consumers are also data subjects. So digital vulnerability arises at the very intersection of 2 disciplines, consumer law and data protection law. So what is digital vulnerability? Now, the time has come to define it. Unlike the traditional approach, which I have explained in the beginning of my presentation, modern universal approach accepts that in digital realm, vulnerability is not the exception. It is the principle. Today, in this realm, being vulnerable is a universal concept. Everyone is universally and potentially vulnerable at different levels and different contexts. But this is the principle now. Why is that? As purchasers and data subjects, consumers provide personal data that is continuously collected, processed, and stored. And digital platforms collect these extensive data across multiple entities. And often consumers are not even aware of this fact. And when combined together, such data creates a huge problem. And the problem here is the architecture of digital markets. Well, the architecture of digital markets today is designed to maximize vulnerability for profit. As it was also mentioned in the previous presentation, in 2024, Italian Competition Authority ruled that TikTok not only exploited pre-existing consumer vulnerabilities, but created new ones. Today, the market is designed in such a way to find out and even also create vulnerabilities of consumers and exploit them. This occurs through data mining, machine learning, behavioral profiling, dark patterns, which will be covered today, targeted ads, and algorithmic decision making. So, in simpler terms, consumer data is used to analyze consumer biases and weaknesses, and consumers are exploited by such information. Digital vulnerability is most visible at 2 key moments. First one is the contracting stage. Consumers are nudged and misled by manipulative design into decisions which are not in their best practices. Another example from TikTok, in 2023, the Irish Data Protection Authority fined TikTok 345 million euros for nudging, especially minors, through dark patterns. The second stage of digital vulnerability is found at the data processing stage because personal data is used to reinforce disadvantage to consumers. Through personalized ads, dynamic pricing, algorithmic profiling, which all target biases of the consumers. Okay, now we have seen the problem. We have seen why everyone is vulnerable at this new realm, which is a digital realm, and how big the problem is. So the second question here is, do we have the legal tools to cope with digital vulnerability? Today I'll focus on 2 European instruments. One is the UCPD, and the other one is GDPR, General Data Protection Regulation, for concerning data processing. Let's start with UCPD. And as I had already hinted, commercial practices are deemed unfair under UCPD if they exploit consumer vulnerability. But with an outdated perspective, with an outdated approach, UCPD regards vulnerability as an exception and adopts a particularistic approach, focusing on specific groups who are deemed to be vulnerable. And it largely relies on disclosure-based mechanisms, which are often insufficient to address structural vulnerabilities that I have just explained. So UCPD is not sufficient to address digital structural vulnerability in the digital area. What about GDPR? Could GDPR be the tool to cope with digital vulnerability? Unfortunately, no. Although GDPR resembles the universal approach in comparison to the particularist one, because GDPR says that in particular children are vulnerable, so it hints that there are other groups of people who can be vulnerable as well. GDPR also assumes, like the consumer law, also assumes that data subjects are rational actors. However, they are not. And the more important problem is that, given its aim and scope, GDPR does not address contractual terms between consumers and businesses. This is an aim that belongs to consumer law, not the data protection regulation. And finally, GDPR has some principles which are not able to offer full deterrence effect, and they function largely ex post depending on the DPA enforcement, because once a breach occurs, the DPA must be informed about this and take action later on ex post and so on. So GDPR is ill-equipped to address digital structural vulnerability as well. So what is the result? The result is that, in my opinion, we need a reform in consumer law. Because digital vulnerability is not incidental. It is structural. It is systemic. It is how the digital market is created. It is something architectural. Therefore, standard legal protections that we have until now, like transparency, informed consent, and the rational decision-making, these do not provide sufficient solutions to this systemic imbalance. Since the problem is systemic, with a broad sense, we need a response, a solution which is also systemic and is broad sense as well. But which legal mechanism can truly address the systemic imbalance? Could we rely on collective redress against digital exploitation? Perhaps, but that is a question for another conversation. Thank you very much for your kind attention.